Good morning, everybody. Thank you all for joining us. We've got a couple more people waiting in the waiting room, so I'm going to just go ahead and slowly start covering our Zoom housekeeping tips, which is how we usually get started. And actually, before I do that, I'm just going to say that I'm glad to be here with you all. I've had a couple of scheduling conflicts, so it's been like a month since I've been here for one of the Q&As, and I'm happy to be back here with everybody. So I'm going to start with the Zoom stuff like I usually do and just remind everybody that if you could please stay muted during the Zoom, we would appreciate that. It just helps cut down on background noise. If you want to unmute yourself to ask a question, you're welcome to do that, but otherwise please stay muted. And if you're newer to Zoom, I'm just going to remind you that your mute button is down on your Zoom toolbar, which for most of us is at the bottom of the screen. That's also where your start and stop video buttons are. So if you want to be on camera, we'd love to be able to see your faces. And if you don't want to be on camera, that's perfectly fine too. So however you guys want to do that. The chat button is also there in your Zoom toolbar. And I'm going to pop a message into the chat right now. So it might start flashing for some of you, depending on your device. The message I put into the chat just reminds everybody how to submit questions. So if you send us a question in the chat and we don't get to it today, or if you think of a question between now and next week, please go ahead and send it to info@condolaw.net before 4 p.m. on Monday. That gives us a day to research our answers to the questions so that we're ready to talk about them on Wednesday morning. The message I put into the chat also includes a link to our YouTube channel. And sometimes when we get questions that are repeat questions, topics that we cover many, many times, Chelsea will email you back, and it's not her decision. I'm the one that tells her to do it. So don't get mad at Chelsea, but she'll email you back and just say, we're not able to cover that topic again, but we've talked about it several times in the last 6 months, whatever the case might be. The YouTube channel is where you can go, and in our particular channel, not the YouTube search bar, but the little search bar for our YouTube channel, you can search by topic there to find previous videos where the topic in question has been mentioned. Excuse me. So as I mentioned earlier, the chat function in the Zoom is for asking questions or requesting that we clarify something that we've said, not for, arguments or discussions like you might see on the CAI message board. So please just keep that in mind. And please do remember that we are not here to give legal advice. We can't do that in this forum. Many of the questions are going to come from communities that are not our clients, but also legal advice requires an understanding both of your specific governing statutes and your specific governing documents, as well as a lot more details about the specifics of whatever thing that you might be dealing with. So keep that in mind when you're sending us questions. If you're feeling like you need to copy and paste paragraphs of your governing documents or write a really, really long paragraph with a lot of facts in it before you ask your question, it's probably too specific for us to give you a specific answer here. We do try to cover the topics generally when we can, especially if we think they're broadly helpful or applicable to people. But you'll also often in that scenario get an email back from Chelsea, also my decision, not hers, to say this is too specific for us to cover in the Zoom. So please do just keep that in mind. And the flip side of that coin, or along those same lines, if somebody sends you one of our video links and says you're doing this wrong because of something Valerie said in the video, you can ignore that because this is not legal advice, right? We don't know any particular situation you might be dealing with. The only person who can give you legal advice is your association attorney. And so this is going to be my periodic plug for you, which is that if your community does not already have a relationship with an association attorney, you should change that now when it's not urgent and when it's not a significant need for your community. That gives you the time to talk to a few different law firms and kind of get a feel for how they operate. Maybe go to an upcoming CAI event. CA Day is coming up in October. Meet a few of the law firms that are exhibiting there and sign up to be one of their clients so that when something urgent does happen, you already have an established and trusted relationship with an attorney that you can call to get advice, rather than having to go through the whole rigmarole of finding and hiring a law firm before you can get that advice for whatever situation you might be dealing with. Another thing we've been reminding you about every week is the Corporate Transparency Act, which is still being challenged at the national level. And we are still recommending that folks hold off before taking significant steps towards compliance at this point, because there's still a chance that Congress could take action and either exempt HOAs or delay the implementation date of the CTA. Unfortunately, they're on vacation right now, so we have to give them a little bit more time before they go back to DC and resume their session. So we're talking with our clients about really holding off until about October 1st before we start advising our clients that yes, they should start taking steps to comply. I also will remind everybody that a lot of the concern that we're hearing from individual board members about the CTA requirement centers around a concern about giving personal identifiable information to your association to then do the reporting to FinCEN. And individual board members can go to the FinCEN website and get their own individual ID number so that the association can then just put that ID number on its own, CTA reporting application or whatever, and you don't have to give your driver's license number and any other personal identifiable information to your association if you do it that way. And for those that are concerned about giving that information to the government, I got news for you. They've already got that information. And so that is just a reminder that we want to give everybody that that's a workaround that allows you to comply with the CTA without having to give your fellow board members, for example, or your association generally more information than you want to share. We do want to remind everybody, as we have been for a few weeks, and this probably will be one of our last reminders, that all of the legislative changes that were voted on in the 2024 legislative session are now showing up and active on the legislative website. So if you search, RCW 6490 voting, for example, where there have been a couple of changes, you'll see the current state of that statute there rather than being referred to the bill that modified it, which was how it was showing up for a while before. As I mentioned earlier, CA Day is coming up on October 5th. If you're not aware of what CA Day is, go to wscai.org, and maybe Chelsea, you could put that website into the chat. That is the Washington State chapter of the Community Associations Institute, and CA Day is an annual conference that takes place at the Convention Center in Seattle. We will be there. Many of the managers and other folks that you see in the Q&A today will be there. It's a great opportunity for educational events and putting faces with names and actually getting to see people in person within our community. So if you're not already planning on going, we think that it's worth considering. And the last thing I'll mention is that we did not get a huge number of questions submitted in advance for today. So if you have a question that you're kind of sitting on that you've been thinking about asking, pop it into the chat. We're more likely to get to it today than we might be like on an average week. So I think that's it before we jump into the questions.
I will just say one final thing. I wanted to congratulate Valerie on her admission, one of 5 people nationally who's admitted to CCAL, which is the College of Community Association Lawyers. It's a huge honor and a huge amount of work that she had to do to put into getting that. So I just want to make sure that we notice you. And if you want to mention anything about what that is, people may be interested.
Yeah, so the College of Community Association Lawyers is part of the National Community Associations Institute, and you have to meet a whole bunch of criteria and submit an application to become a fellow of the college. And there are fewer than 175 attorneys nationally that have been admitted. And I'm the first woman in Washington State. So I hope the first of many. I hope lots more. We've got amazing attorneys in Washington that practice in our practice area. And so hopefully we will be joined by more of them in the future. So thanks, Lisa. I am going to go ahead and jump us into the questions then without further ado. And thank you all, by the way, for your congratulations in the comments. The first question is this: are there any provisions or restrictions for an annual homeowner meeting? We were considering having the meeting in the community park, a board member's garage, or an online meeting. The short answer to this question is probably not. As far as restrictions, you can probably have the meeting wherever you want, unless your governing documents have specific restrictions in them. We have totally had and even attended association meetings or budget ratification meetings in a parking garage, in the cabana, in a local meeting room, in a library, at a senior center. So we have a lot of communities that have a lot of different locations where they hold their meetings. As long as it's reasonable, So what do I mean by reasonable? Unfortunately, there's not a really clear, always true definition of that. But I would say, it probably shouldn't be an hour away from your community. But if you're holding the meeting at a park or in a meeting room at the library that is, 15 minutes away from your community, that's probably okay. Online meetings are also very clearly allowed by statute without a physical meeting location, or combined with a physical meeting location. So we do have some clients that'll do their annual meeting or their budget ratification meeting primarily on Zoom, for example, but that will also have like a laptop set up in a meeting room at the community for folks to attend in person if they don't have Zoom or don't know how to use Zoom. So if you want to look more specifically at the statutory restrictions and allowances around meetings, just Google your governing statute and the word meeting. So RCW 6490 for Wakaiowa plus meetings, and then it'll take you to subsection 445 of Wakaiowa. In the new Condo Act, it's RCW 6434-332, and in the HOA Act, it's 6438-035. So some of the statutory requirements include things like you have to have your meeting an annual meeting once a year. You can have more if there are special meetings for a specific purpose. You do have to give notice of the time, date, and location of the meeting, and you have to give at least 14 days notice of the meeting and not more than 50 days notice of the meeting. So one thing you might pay attention to is, do the notice requirements in your documents look a little bit different than that, and figure out how to comply with both of them. So maybe your documents say you can give as little as 10 days notice or as much as 60 days notice. You want to comply with the statute and give that minimum of 14 and that maximum of 50. So sometimes that means your notice requirements are broader in your documents than what the statute allows. Sometimes they might be the same on one side and longer or shorter on the other side. Just make sure that at a minimum you're complying with the statute, and whenever possible, you can also comply with any additional notice requirements in your documents. I do want to say one other thing with respect to holding virtual meetings. You need to conduct the meeting via a means that allows two-way participation in the meeting. So it can't be broadcast only. It has to allow owners the opportunity to talk and to vote, for example. You have to figure out a way to track votes if you're voting on things at the meeting. And for anybody who, let's say, doesn't have a smartphone, you do have to provide an alternate way for them to call into the meeting that also allows them to hear and speak. And Zoom does that automatically. Whenever you create a meeting in Zoom and you copy the Zoom information, it gives you a link to just jump into the meeting via Zoom itself, but it also gives call-in phone numbers that people can use to participate in the audio part of the meeting, even if they don't have Zoom installed on their smartphone. So that is something that is important to make sure you do have the ability to provide. And I would also like to actually see that alternate call-in method called out specifically on the meeting notice. If it isn't, you should probably at least put something in there that says, to participate in the meeting without the use of Zoom, contact the manager or the board for call-in information or something like that. Lisa, did you have anything you wanted to add on that one?
I would just say that we have had lots of conversations about the Zoom type meetings in the past, so that this is one of those good opportunities. You can do a search on our YouTube channel for lots of discussion about that previously. Okay, next question. Are projected expenses for reserve components included in the annual budget? The short answer to this question is no. You do have the contribution to the reserve account included in your annual budget, but not expenses related to that reserve account. You could, if you wanted to, identify expected reserve expenditures, but it's not required. You need to, income outgoing. That's basically what you put on income, and expenses are what you put on your budget. Your reserve study, however, should include all of your expected reserve expenditures for the year and for future years. And we've talked about this a lot, but there are, very specific requirements for what your budget packet has to have covered. Everyone is covered by this. It appears in Wakaiowa, but it covers all associations. RCW 6490-525. It has the list of requirements that are in there, and one of them is a statement of whether you have a reserve study that meets the requirements that we were talking about, and the extent to which that deviates from the recommendations. So there you have a little bit of a spot to kind of put, do we have a reserve study? Is it compliant with what we're supposed to be doing? But that's just about the reserve account itself, not what's going in or what's going out of the reserve account. So just know that that's only just telling owners we have one, this is what how much is in there, and this is what we are hoping to have in there at the end of the year, and how much we're giving, how much of each assessment is going into that account. But generally speaking, no, if you are spending money from your reserve account, that is not something that needs to be on your budget. Valerie, did I miss anything there?
No, I think, just not to put too fine a point on it, but the whole point of a reserve study and a reserve account is that you're saving and planning for expenses that are not covered by your normal annual budget, right? So if it's a reserve component, your repair and replacement schedule and expenditures are part of the reserve study and the reserve account. You don't have a separate line item in your budget. And part of the reason why is that you would have this, let's say you're replacing your roof this year, and that's going to cost you, let's pick a round number and say $500,000. If you don't have income showing on your budget sheet to provide for that $500,000 expenditure, it's going to throw your budget completely out of whack, right? So the budget, your normal budget, your annual budget includes all of your operating expenses. Your reserve study and your reserve account are where you track reserve components and their repair or replacement.
There's nothing to say that you wouldn't maybe tell your owners, remember, this year we're spending $500,000 out of the reserve account for a roof, but it doesn't require it to be laid out.
Yes, absolutely. I wanted to add something sort of related to that, which is I just copied and pasted into the chat the section of the statute that Lisa was talking about budget ratification and what is required to be on the budget notice that you send out to your owners before the ratification meeting. There are a few things that we often see missed. One of them is the date the assessments are due. And I think probably that's because, if you're in a condo association, of course, everybody knows the dues are charged on the 1st of every month, but your budget's supposed to have that in there. So we know we're kind of rolling into budget season. Some of you managers, I'm sure, are already in the thick of it. Keep that in mind. Another thing that we often see missed is a statement of whether the association has a reserve study that meets the requirements of WCIOA. It also has to include a statement of whether the budget meets or deviates from the reserve study recommendation and to what extent it does that. And then the biggest thing that we see missed is the last requirement, which is the current deficiency or surplus in reserve funding expressed on a per unit basis, not a total deficiency, not an average deficiency, but a per unit deficiency in reserve funding. So let's say you've got, let's say your reserve fund is short, is $100,000 short of where your reserve study professional is recommending that it should be funded right now. You're not disclosing the 100,000. I mean, you can and you should, right? You're not saying it's an average of $5,000 per unit unless all of your allocations are equal. What you're telling owners is based on the percentage allocation for each unit, the reserve fund deficiency for your unit is, and it's, calculated on the percentage allocation for that unit. So just because we're in budget season and we had the time, I thought it might be worth sort of calling out the most common omissions or mistakes that we see in that. Lisa, did you want to add anything to that? We review so many of these because of our collection files.
Yeah, I was going to say, I think that you're right. The assessment due date is one of the biggest ones. I'd say almost 90%. And it's such an easy thing just to add to your cover sheet. Reminder, all assessments are due on the 1st of the month, beginning January 1st.
Right.
That would be compliant. I will also say that Valerie and Ken, I think last year, did a budget primer video on our YouTube channel. And if you can't find it by searching that, shoot us an email at the info@condo.law and we can send you a copy of that. But it's I think it's about an hour, maybe less.
Yep.
And it kind of walks you through how to do a budget. And I think it's really helpful if you're, even just a reminder for those of you who've done them every year. Sometimes it's just make sure you don't forget something, because the worst possible thing is to have me or Valerie or Tima say to you, we can't collect these assessments because it wasn't done right.
So your budget.
Yeah. So get it done right this time. It's great.
Yes. All right, I'm going to move on to our next question. Should an estimate of possible late fee and penalty income be included in the annual budget for determining how much each lot is assessed. What happens to late fee and penalty income at the end of the year if they were not included in the annual budget? Okay, so I'm going to answer the first question first, which is, should you include late fees and penalty income in your annual budget? I'm going to say no. I'll explain more. And what happens to that money at the end of the year if it wasn't included in the annual budget? It's just unbudgeted income. So I want to remind everybody that a budget is not set in stone. It is a spending plan, right? Just like you might for your family have a budget and think that you're going to spend $250 on groceries this week. Sometimes you spend 200 and sometimes you spend 300. Or if you get a bonus at work, you might have a budget that's based on your base salary, right? But then you get a bonus and that's just a little bit of extra money that you have at the end of the year. So I think it's important to remember that a budget is a spending plan, not something that is set in stone. Again, if you go back to what is required to be in the budget, it's 6490,525, and that's the statute that I just copied and pasted part of into the chat. I think it's also important to remember late fees, interest, and fines are not intended to create an income stream for the association. And so at the end of the day, for most communities, we're not talking about a significant amount of money here. We're talking about a relatively insignificant amount of money. And you would not include them in the budget because there's no guarantee, there's no way to predict them. Where, for example, assessments, of course, you include in the budget because you know exactly how much at least you anticipate collecting, because every unit has to pay. Let's say you're in an HOA, equal assessments, every lot has to pay $250 a year. That's predictable income. You can look at your last 3 to 5 years of delinquency rates and anticipate that 95% of your owners are going to collect. And so you set up your budget accordingly. Late fees, interest, and fines can vary wildly from one year to the next, and they're not guaranteed income. So it just doesn't make sense to include those. If you do collect late fees, interest, and fines, and that were not part of your budget, then you just have a surplus at the end of the year. You can go ahead and put that surplus into your reserve fund. Most communities, as we have witnessed in terms of reviewing budgets, are not fully funded in their reserve accounts, or even many are not even at baseline funding. So that's a great idea. And you can also certainly ask your accountant if they have specific advice for how to handle those excess funds. I want to say something sort of that's related to this, and I briefly alluded to it before, which is that you should, in your budget process, be planning for delinquencies and for the legal fees and costs you might have to pay to address those delinquencies. And so here's what I mean by that. When you're putting together your budget, if you know that you're going to have 100,000, I love round numbers for the purposes of these examples, right? If you know that you're going to have $100,000 worth of expenses this year, and you create an assessment schedule that allows you to collect exactly $100,000 worth of income from your owners, without accounting for the fact that you have a 5% delinquency rate, maybe, you're going to be short this year. And so what we tell our clients to do when it comes to budgeting for unpaid assessments is look at the trend as far as your delinquency rate for the last, say, 3 to 5 years. And if in that time frame you've collected on average 5% less than the amount of the assessments you needed to collect, or that you were charging, set your budget up so that if you collect 5% less than what you're assessing to your owners this year, you can still pay your bills. So that's one part of this strategy. In addition to that, you should be budgeting for legal fees so that when you send an account to your association attorney to record a lien or send a demand letter, or if an owner files bankruptcy, you have your attorney appear and advocate for the association's best interest in that process. You want to make sure that you've budgeted for those legal fees. We realize that sometimes that feels a little counterintuitive because the intent here is you spend those legal fees, you assess them to the owner, and then you eventually collect them when the balance due is paid in full, as it often is when you're using an attorney to help you collect them. And under accrual accounting, which is the type of accounting that is required by statute in Washington state, attorneys' fees for collection efforts end up being neutral as far as your balance sheet is concerned, because they're a liability because you have to write a check to pay the attorney, but they're also an asset because the owner is obligated to pay the association back eventually, right? So all of this is just a reminder that when you're putting your budget together, you're not just thinking about the total amount of the assessments charged and the total amount of your expenses. You should also be looking at your history in terms of delinquencies, what you're actually likely to collect from your owners, budgeting for legal fees, and setting yourself up so that your budget doesn't operate on such a razor thin margin that if an extra person doesn't pay their dues this year or sick for 6 months or whatever, that you can't pay your bills as they come due. Lisa, did you have anything you wanted to add to that?
I don't think so. That covers it.
Okay.
Okay, the next question. Can you please define personal delivery and hand delivery as allowed in the RCWs for giving notice? Specifically, the board is wondering if it is okay to tape notice to a member's front door or place it in their newspaper holder, or does it have to literally be handed to the recipient? I will say that this question, we had a lot of conversation about this question because it's a very good question. And those are not defined terms in the statute. Both are indicated as possible means of delivering in addition to mail and other things. And you can look at your specific statute. Personal delivery is in Wakiowa 649515. It says notice is provided in a tangible medium is effective as of the date of hand delivery, which as the question asks, what is that? We think that means actually handing it to someone. But the question is, what does personal delivery mean? Does that mean if I stick it on their door or I put it somewhere else, does that count as well? And we had, as I said, we had a lot of conversation about this. I mean, I think most of the statutes and most of your documents, the statutes, what is required now is to deliver it by mail. You have a certainty that it is compliant with whatever notice requirement you have and whatever statute you're talking about. It doesn't matter if it's received or not. And it is out of your hands, so to speak, as soon as you put it into the mail. But if an association is looking to do something and if their documents and statutes allow for a personal delivery, I think you actually have to hand it to a person. I think that putting a notice on the door for something like a budget meeting, for a fine late notice, something like that, you actually need to be very specifically compliant with personal delivery, means handing it to a person, or hand delivery, or by first-class mail. We've had lots of conversations too, I just want to add, about certified mail. We don't think that unless it's specifically required, is a fantastic means of, is not a fantastic means of getting notice to people. Regular mail will go through. Certified mail, if it doesn't get picked up, will get returned to the sender immediately. So, and you'll never know if a person saw it. So anyway, regular mail is what we're talking about here. When we were talking, Ken mentioned that he thought that if there is an adult who resides in the house and you walked up to the front door and you handed it to them and they weren't the person who was supposed to get it, that probably is compliant. It is compliant if you're talking about service of a lawsuit or something like that, which we do a lot. So that is potentially acceptable. But I think the real key here is good faith notice. Did the person get a copy of the notice that you're trying to give them, and what is required to do that? I think unless, we talked about this, unless the notice is something emergent or construction or something you need to get access to a unit, you don't know who lives there, sticking it on the door is not a great way of getting notice to somebody. And I don't think that complies or is a good faith effort of hand delivery or personal delivery. There's no interchange whatsoever. It's literally just taping it on a door. We tried to do some research on the topic, and surprisingly, there isn't a great description of what those things mean in the cases either. One case in Washington, I think it's from a couple of years, in 2005, said that someone left a copy in a mailbox and the court said this method of quote unquote service did not comply with the rules substantially or otherwise, so probably not. Sticking it in their newspaper circular or sticking it in their mailbox, probably not compliant. But I think you really need to look at what notice is required, because it may be different depending on what you're trying to provide to the person, and make sure that you are complying with that. The cost of mail is so low in comparison to the person hours of walking door to door, trying to make sure someone's home, that I just think, and we've talked about this before, that mail is really the gold standard, is really the best way to make sure you get required notice out to people. But if you're committed to walking door to door and waiting till someone answers the door, I suppose handing it to them is probably okay. But then you have a whole proof problem. You know, how are you proving that you did that? With the mail, at least you have a stamp and a postal notice on the envelope. Anything I'm missing there, Valerie? There's a lot we talked about.
Yeah, I just would like to emphasize that it probably depends a little bit on the type of notice. So if what you're trying to do is tell somebody the water is going to be shut off to the building on Friday because of a water main repair or something, we have no objection to you posting those kinds of notices on the door of the house or the unit. Okay. It's not that we're saying don't do that under certain circumstances. The question is, when notice is required under the governing documents, if you're amending the declaration, if you're holding an annual meeting to do an election, if you're voting on an amendment, if you're ratifying the budget, whatever the case is, then we look more closely at what the statute allows and requires in terms of notice. It does allow personal delivery, but because there isn't a whole lot of case law out there interpreting what personal delivery means, then we have to think, what is a court going to think is personal delivery? And I don't want to be somebody standing in front of a judge arguing that sticking a notice in a newspaper delivery slot is personal delivery under the statute. I don't think that's a reasonable interpretation of the language. I think one of the things that we've talked about a lot in this Q&A on a number of different topics is that when there isn't specific guidance in terms of interpreting a statute, looking at another statute, that in relying on another statute and what it does say as a reasonable guidance for that thing is helpful. So for example, before all of the governing statutes were amended to include their own records section, 3, 4, 5 years ago, when Wakiowa was enacted and it did have a records section, we said to people, the Condo Act is silent on this particular issue. We think it's reasonable to rely on the records section of Wakiowa, and we think a court would agree that that is a reasonable thing to do because it's indicative of the legislative intent, etc. There is statutory guidance and case law out there about personal service of like lawsuits and stuff. And when you talk about personal service, there are two things that you can do that qualify as personal service. Either hand the documents to the person that you're trying to serve, or a co-resident of suitable age and discretion. So don't hand it to their 12-year-old kid and call that personal service. Don't hand it to the mailman who's standing outside of their house and call that personal service. Do hand it to their spouse or their roommate who is an adult. That would probably be fine. The other method that's approved for personal service is something called drop service. So if you are talking to somebody and trying to hand them documents and they refuse to physically accept the documents from you, if you're still in their presence, you can drop the documents at their feet, and that's an acceptable way of making personal service for a lawsuit. Okay. Taping something on the door, leaving it in the mailbox, sliding it under the door, even if you know that they're there. All of those things are not acceptable methods of giving personal service when we're talking about a lawsuit. And so I would look to that for guidance in interpreting this. The other thing I would like to flesh out is some of what Lisa said about the cost of sending things by mail. I suspect this kind of question is not coming from a community with 300 units or 1,000 homes, right? Most of the time, people who are actually considering whether personal service is an acceptable method of giving notice, we're talking about smaller communities, 8 units, 20 units, whatever. You live on site. Most of the owners live on site. So I think you're probably not hand delivering because of the cost. At least that would be my guess, because sending 20 notices of an annual meeting would be inexpensive compared to sending 300 notices, etc. So I think part of what I need to remind everybody of is another thing, which is a tenant living in the home. You can't deliver a document to the tenant and call that personal delivery to the owner. So I want to remind you that your relationship as an association is not with the tenants, it's with the owners. And so again, if you want to walk around your community of 20 condo units and hand deliver notices to all 20 owners and they're actually physically present and you do it that way, that's fine. But I want to emphasize how unlikely I think it is that a court would find delivery to a mailbox or taping something on the door to be effective notice when we're talking about notices that are required by statute. And it looks like somebody sent a comment directly to Chelsea that said, this association posts meeting notices on the neighborhood cluster mailboxes. Is that considered a legal notification? So I don't want to answer a specific question about a specific HOA and whether they're giving proper notice. What I will say is we have clients that do post meeting notices by the mailboxes or, other places where a lot of folks might see them coming in and out of the community. I would tell a client in that scenario that shouldn't be the only way of giving notice of a meeting when notice of the meeting is required. There's a lot of stuff I don't know about this scenario, which is are notices required? A lot of communities don't have open board meeting requirements. And therefore, if they are posting discretionary notices, that might be just fine. So I can't speak to that specific situation, but I think we've covered it well enough here. And if you have follow-up questions, you're welcome to put those in the chat or send them to the info@condo law email address. Lisa, did you want to add anything before I move on?
Nope, go ahead.
Okay. I am board president of a 30-unit, 2-building condominium in Bellingham. We are experiencing considerable debate regarding our reserve study and reserve fund. Some board members oppose following the study's recommendations regarding payments into our reserve account. I am in favor of staying within the numbers on the study. Can you suggest some arguments I can use to convince people of the importance of following the reserve study? I don't think I need to make the argument. I think the legislature makes the argument for us, right? If the legislature did not think and I think it's really easy to point to, very dramatic scenarios like the Surfside condominium collapse in Florida as the potential risk in certain types of buildings and locations of long-term deferred maintenance, which can often be an outcome of failing to fund your reserves adequately. There are other consequences connected with failing to fund your reserves properly. Poor reserves can result in banks refusing to loan money to people who want to buy or refinance within your community. The whole point of the study is that it's going to show when your association is likely to run out of money. And if you run out of money when there is a reserve component that has to be repaired or replaced, you are risking a large special assessment. And the point of a reserve study is to spread out the cost of repairing and replacing reserve components over a long period of time so that owners pay little bits and pieces of that cost in each year where they reside in the community, which is a more fair allocation of those expenses than just specially assessing every time you have a big expense coming up, which places all the cost burden of that component on the people who live there in the moment when the special assessment becomes due, right? Poor reserves are also likely to reduce the value of the properties in your community and lower their prices when they're being sold. So if you're looking at, arguments in favor of funding your reserves in accordance with the recommendations, I think those are all factors that you can point to. I will offer that there are definitely different funding approaches, and different reserve professionals may recommend baseline funding. They might recommend full funding. They might recommend, there's different funding approaches that can be recommended at different times. And it's not unreasonable for a board to look at the actual upcoming schedule of reserve component repair and replacement, the actual amount of money in your account, and make slight adjustments to funding the reserve account based on the timeline and the likelihood that you're going to, maybe you can get 3 more years out of that roof before it needs replacing based on its current condition, etc. So I don't think that I think it's important to note the difference between a reserve study, which is a funding plan, and a maintenance plan, which is when you actually do the work, right? Sometimes the reserve study says the roof has to be replaced in 2024, but your roofing professional comes out and says, you can get 5 more years out of this roof. It's perfectly fine. We can replace a few shingles or whatever, you know, and so it's important to recognize that it's a funding plan as opposed to an actual building maintenance plan. So there is some flexibility there, but we are big fans of complying with the statute, and complying with your reserve study recommendations in terms of funding the reserves. So I hope some of that's helpful. Lisa, I don't know if there was anything you wanted to add to that.
I missed a little bit of the beginning. I'm not sure if it was just on my end. I just did want to mention that, and you probably already did, that no one likes special assessments. So,
Oh,
you
yeah.
know, I think that's a key here. If your owners are going to be confronted with a huge special assessment because you need a roof replaced or whatever it is, because the reserve fund was not appropriately funded, that can be a real bummer later. So just keep that in mind. And I think keep in mind that you're required to put a disclosure on your reserve study, or the reserve study folks are required to put, that basically says the failure to include a component or to provide funding increases, you know, can be deferral of maintenance, can increase future reserve contributions, force you to borrow money later, or impose special assessments. So I think, you know, just kind of keep reminding your fellow board members of those types of things that may come up.
Yeah, you know, I want to add to that. That's a really good point. And resale certificates, if you don't have a reserve study, you're now required to include this statement on a resale certificate. This association does not have a current reserve study. The lack of a current reserve study poses certain risks to you, the purchaser. Insufficient reserves may, under some circumstances, require you to pay on demand as a special assessment your share of common expenses for the cost of major maintenance, repair, or replacement of a common element. So funding your reserves is important enough that the statute requires a reserve study. The legislature requires disclosures related to budget disclosure, ratification, I should say. And it requires that statement on your resale certificates if you don't have a reserve study. So I guess, you know, if I were being really blunt with a client that knew me well enough to know that I wasn't trying to be a jerk and saying it, the question I would have is, why do you guys as a board think that your judgment is better than your opinion is more important than the opinion of a reserve study professional, the opinion of the legislature, which has studied this issue fairly extensively, etc. So those are some of the hard questions I might ask.
Okay. Next question. Scenario: we are a tiny condo under 6434. We have a single member on our board who disagrees with nearly every issue, abstains or no votes on most decisions, accuses board members of self-interested motives, and worse, incessantly demands rapid retrieval of recent and past invoices from the treasurer, inundates our inboxes. I think you all get where this is going. This association does all of their meetings over Zoom, so now they at least have the power of the mute button to make their rambling circular diatribes less, as they note that it was an idea from Valerie. The question is there a norm or legal limit to curtail this, or is the only solution for our board to suck it up and learn to endure? I will start by saying that this is no fun. Unfortunately, it's one of the side effects of community living, I think, is that we have to learn how to deal with difficult people. And we've definitely had lots of conversations in the past couple of years about this. So if we don't cover it to your satisfaction, you may also want to look and see if we've brought up other ideas previously. I think one of the things that we've talked about a bunch is a code of conduct for your board. It might be something that's helpful to kind of point out to the person, you know, talk to your legal counsel about what might go into a code of conduct. It's something you can certainly find online too, but I think talking to your counsel about, you know, what kind of things you might want to put in there. But that would be things like, you know, how board owners conduct themselves at meetings, what kinds of things, how to act respectful, which seems crazy, sort of like the kindergarten rules for everyone. You can also impose a communication and harassment policy. That might be something that for the entire association, but also helps monitor or curtail board malfeasance or improper conversation or behavior. You may also want to have someone else be at the meetings with you. We have some clients who I know they hire Ken, or they hire other folks to serve as a parliamentarian or their attorney and runs the meeting. And that person basically has the power to turn people off, mute them, go on to the next agenda item, that kind of thing. And that might dispel some of the, I don't know, animosity between other board members if you have a total independent third party running that meeting. So that's an option. You could also have a policy that says that only the business that's on the agenda is conducted at the board meeting. We're not discussing anything else. You can also say we're not discussing board actions via email. Everything is discussed at the board meeting. And as Ken pointed out, that's what Kyle wants you to do anyway. So, have a policy. Only board business is discussed at board meetings. We don't discuss it anywhere else. And then you stick closely to your agenda. I know that there's something else I was thinking of talking about. The other option is, you look at your documents, there may be a way to recall this board member. That's sort of a nuclear option, depending on the size of your association and whether this person is really hampering the business of the board. Doesn't sound like they're contributing a ton. They're abstaining on most votes. So that's a possibility. Check your documents and see whether or not in your bylaws you have a method for recalling. You also just might be able to strip them of their officer position. That doesn't require the community as a whole to get involved. That's something that the board could potentially do and basically so maybe they're the secretary now. Basically, they're still a board member, but you've removed their executive position from them. And sometimes that may have at least a signal to them to dial it down, that you're taking seriously their interruptions to your flow of business. And certainly you can talk to your attorney if you have really specific questions, if this person's becoming harassing or other things to other board members. But it sounds like mostly they're just sort of gumming up the business, which is not a simple thing, but it may be able to be handled by setting kind of strict policies and sticking to your agendas at the meetings. Anything I missed there, Valerie?
Yeah, I would add a couple of things, both of which are related to boundaries on the part of the board as a whole. So one is, if you have a strong personality running your meetings, it is their job to keep the meetings on track. And that's not to say it's an easy job when you're dealing with a difficult person like this, but the less likely that person is to be bullied into allowing more time or energy to this person, the better. The more streamlined your meetings can be. In addition to that, and along the lines of having boundaries, just because they're sending you emails all day and all night doesn't mean you have to respond. Doesn't even mean you have to look at them when they come in. You guys are all volunteers, and the pay as a board member, as I often joke, it kind of sucks, right? You're there giving freely of your time and your energy because you're trying to benefit your community. And you do not have to be available at all hours anytime somebody sends you an email or calls your cell phone or texts you or whatever. So some of the things that I would suggest include giving yourselves, as the rest of the board members, boundaries in terms of how available you make yourselves to feed into this person's energy. And so some of what that might look like is stop using your personal email address for anything related to association business. Set up a, I don't know, like abccondo@gmail.com, abccondopresident@gmail.com. Set up separate email addresses for each board position within the community. This has the added benefit of creating sort of a long-term institutional, I don't know, paper trail within that email address, so that when a new person is elected president, you can pass that email address on to them. And then the next person gets that email address, et cetera, et cetera. So there's some other benefits unrelated to this subject of taking this approach. But if you have this separate email address and they're no longer sending emails to your personal email, and then you can just tell them, I'm no longer accepting association emails at my personal email address, I'm going to block you. The other thing you can do is give yourself a schedule, check that email. It depends on the community, how involved you are, what your time looks like as a board member. I don't think it would be unreasonable to say, I'm only going to check that email once a week or twice a week, and then just ignore it otherwise. And also remember, not every communication from a problematic individual like this, board member or not, requires a response. So sometimes it's just read it and Okay, fine, read it next, read it next. Not everything requires a response. So it's so frustrating because it requires you to be really proactive and really mindful based on the bad behavior of somebody else. And that's lame and annoying, but it's just part of life sometimes, unfortunately. And I think having some of those boundaries and rules in place for your own protection also can have the effect of making certain people kind of simmer down and go away when they're not getting the response that they want. So that's the other piece that I would add to that.
I would also just add, Valerie, is from a legal standpoint, having emails that are association specific and not your personal emails really cleans things up if the litigation happens and you only have to turn over the association emails, not your personal emails. So
yeah,
just another plug
all
for
right,
that.
here's our next question. Under Wakaiowa, the board and its decision-making committees are required to hold open meetings and meet timeframes for notices of these meetings to give owners sufficient time to plan ahead or have meetings held on a schedule. Our Architectural Control Committee had been meeting to discuss requests as they came in and respond back to owners in a timely manner as required by our CC&Rs within 30 days. Often there were questions back and forth with the owners and sometimes visit to an owner's property to discuss the project. It appears that under Wakaiowa, the discussions of the ACC board members need to occur in an open meeting with notice or in a meeting on a scheduled basis, as well as the discussions with the ACC and owners. We are concerned this could significantly increase the time for a decision. Are we correctly interpreting how the ACC should operate? The short answer to this question is probably, but it may not actually affect your timeline as much as you think it will. And part of why is that you could start having standing ACC committee meetings, perhaps in connection with the time that the board already meets monthly, because it sounds like this is a pretty active committee. So rather than meeting on an as needed basis, only when applications come in, you can have a monthly ACC meeting. And it could literally be 5 minutes, call meeting to order, no business to discuss, adjourn meeting, right? But if you've got that regular meeting set up, you've got the sort of infrastructure meeting wise in place to discuss things as they come up and to continue to be timely in your response to those applications. So the statute in question is, well, there's two subsections here. RCW 6490-410, subsection 6. And that talks about committees authorized to exercise the power of the board. And RCW 6490-445, subsection 2 is the one that talks about open meetings. I do think that you're correct that committee meetings, in particular committees that exercise the authority of the board, are required to be open and are held to the same standard as board meetings when it comes to being open, notice to your homeowners, etc. So I think the easy solution to this concern is schedule a monthly ACC meeting. It can literally be 2 minutes long if there's no business to discuss in that month, but it puts the process in place to be timely and sort of nimble in response to these requests when they come in months where you do need to respond to an owner application. Lisa, did you have anything you wanted to add to that one?
No, I think I would add a little bit to the part about what makes up the committee. I mean, it's pretty specific. So a committee that has board powers has at least 2 board members on it. So I suppose if you had a committee that had no board members on it or less than 2 board members on it, you may or may not be required to have the same meeting requirements. But that's, it's kind of getting into the weeds a little bit.
Yeah. Okay, well, I'm going to jump to the questions from the chat. Here's the first one. Our association manager just sent out this message as part of a draft invitation to owners to apply for a board position. If the HOA cannot find board members in the upcoming years, the association must notify legal counsel, which will notify the court, and the court then appoints another entity, usually a retired judge, to act as the board for the association. This is called a receivership. Is this true or false? And what is the source of this rule? A receivership is one possibility when an association cannot seat board members. It is a last resort. It's extraordinarily expensive. It doesn't always mean that it's a retired judge. Sometimes it's just a lawyer that does receiverships. But this is a possible outcome if there are no volunteers to serve on the board. I imagine part of what your manager is trying to do here is educate your owners on the risks of nobody volunteering for long enough and the potential cost to the association. In reality, there are certainly a lot of steps between where you are now and eventually getting to that point. And in reality, it's relatively rare that this actually happens. And we have in previous Zooms covered strategies to deal with low turnout in terms of volunteers for the board and steps that you can take to keep you from getting to the point of a receivership. So I think if you search for either receivership or volunteer or board service or whatever in our YouTube channel, I know we've covered this subject probably 3 or 4 times in the last year at least, and you could look through our videos on the YouTube channel and get some ideas for strategies to implement before you get to that point. Lisa, did you want to add anything to that?
No, I think it's just, it sounds like they might be getting a little frustrated with not having volunteers. And so this manager's trying to kind of do a little scare to people. And so, I mean, it is theoretically possible this could happen, but it's usually unlikely.
Yeah. And that's the other thing. I mean, I guess one thing that's worth mentioning without going super deep into this topic, because we've covered it so many times before, if you currently have, let's say you have 5 board members required by your documents, and you currently only have 3 board members serving. The board members that are serving now should appoint 2 owners to fill the 2 empty positions. If you can't get 5 members, that doesn't mean that your 3-member board can't govern the community as they are, on the board now. They can. Ideally, of course, always the goal is to seat a full board, but not having a full board doesn't mean that you can't do association business. And so the interim steps would include each time someone steps down from the board, whether it's because they're just no longer interested in serving or they're selling their home or whatever the case might be, hold an election. If you can't get quorum for an election, appoint a replacement to serve in that position until the next election, so that you never get to the point where there's just one person left on the board. What do you do when they sell, or whatever the case might be? You're trying to take really proactive steps so that you never put yourself in that position. There's a couple more questions in the chat. One of them is short enough that I think we have time to cover it. And it is this one. Isn't there a percentage limit for a special assessment that can be declared by a board before having to get a vote of the owners? So I suspect this question might come from somebody who lives in an HOA governed by 6438. It is generally very common in HOA CC&Rs to see either a cap on the increase, on the amount that you can increase assessments from one year to the next without an owner vote, or even a cap on the amount of a special assessment that the board can implement without a vote of the owners. But this all predates RCW 6490-525, which is the budget ratification process that is prescribed by Wakiowa, which is applicable to everybody. And that requires special assessments to be ratified by the ownership all the time, period. It is possible that a CC&Rs might contain additional restrictions related to special assessments for a specific community, but it's no longer possible for a board to impose a special assessment without a ratification vote of the owners, which used to be possible before the budget ratification process became applicable to everybody from Iowa. So I can't answer this question for a specific community because I don't know what your CC&Rs say, but what I can tell you is there's no such thing anymore as a special assessment imposed by the board without a vote of the owners. Special assessments have to be ratified in the same manner that your regular budget has to be ratified. But it is possible that your CC&Rs have an additional, more hoops to jump through when it comes to special assessments. And the only way we could answer that would be to look at them and give you advice on your specific language. Somebody asked for the budget training link in the chat. I don't think we'll be able to find that quickly enough to put it into the chat, but if you would like to email info@condolaw.net, then Chelsea can find the link in our YouTube channel for the budget ratification primer, I guess we'll call it, that Ken and I did. I think it was maybe 2 years ago. And she can email that back to you. Lisa, did you have anything that you wanted to add before we wrap up? We're at 10:59, so I don't think
No.
we're going to have time for additional questions.
I think we're all good.
Okay, well, thank you again, everybody, for joining us today. We were happy to have you here with us. If we didn't get to your question, please email it to info@condolaw.net, and we will see you all here next week. Bye.
Bye.